B.R. Ambedkar quoted that once B.R. Ambedkar said that, I quote, law and order are the medicine for the body politic, and when the body politic gets sick, the medicine must be administered. Yes, indeed. Uh, Good evening, ladies and gentlemen. I take up this platform to extend a humble salutation to our distinguished guests and all the participants who have actually virtually gathered here today. I, Hadi Febin, student of University Law College, Bangalore, University, considered it as a proud privilege to be the master of ceremony for the celebration of the Constitution Day 2020. I take this platform to extend the greetings to the faculty of University Law College, Department of Studies in Law, Bangalore University. I now invite the Ms. Divya Sri, student of University Law College, for the invocation with a saxophone.
Thank you, Divis.
Thank you, Divashri. That was indeed a great, gracious invocation. So, Constitution Day, also was known as Samvidhan Divas, is celebrated in India on 26th November every year to celebrate the adoption of Constitution of India on 26th November 1949. The Constitutional Assembly of India was adopted the Constitution of India and came into effect in 26th January 1950. The Government of India declared 26th November as Constitution Day on 19th November 2015 by a Gazette notification. Dr. B.R. Ambedkar, who had chaired the drafting committee, had played a vital role in the framing of the Constitution. 26th November is indeed was chosen to spread the importance of the Constitution and spread the thoughts of and ideas of B.R. Ambedkar and other famous of the Constitution. And it's indeed an esteem to have with us the chief guest for today's auspicious day, Srimati Indra Jaising ma'am, senior advocate, Supreme Court of India, and Professor K.R. Venugopal, Honorable K.R. Venugopal sir, Honorable Vice Chancellor, Bangalore University. Now I request our beloved principal, Professor Dr. Suresh V. Naudagowda sir, Principal, University Law College, Bangalore University, to deliver the welcome address.
Thank you, Mr. Pevin. Good afternoon, everyone. At the outset, I take this opportunity to congratulate all the honorable guests and all the participants on the eve of Constitution Day celebrations today.
You'll have to help me when I get
Esteemed chief guest of today's program, Senior Advocate Madam Indra Jaising, Honorable Vice Chancellor, Bangalore University, Professor K.R. Venugopal sir, my esteemed colleagues, President of the Alumni Association and members of the Alumni of University Law College, professors of other departments of Bangalore University, and principals and faculty members of various law colleges, dear students. Indeed, we are very happy and privileged to have with us Madam Indra Jaisingh today, who has kindly consented to be the chief guest and accordingly grace this program. Madam is well known throughout the country as an eminent advocate who has championed the cause of the environment, human rights, women rights, rights of children. Particularly, she has rendered her valuable contribution for protection of rights of the poor and the downtrodden. Madam, once again, I thank you very much for accepting our request and gracing us. And I, on behalf of Bangalore University, Honorable Vice Chancellor, and the University Law College, I extend you a very warm welcome to this program. We have our own Honorable Vice Chancellor, Professor K.R. Venugopal sir, who is an eminent academician and an able administrator who has a long-standing experience of academics for more than 40 years, who has rendered valuable contribution by contributing more than 700 research articles, authored more than 40 books, and he has more than 10 patents to his credits. And indeed, Honorable Vice Chancellor is a source of inspiration for all of us in the University Law College to conduct series of activities. I, on behalf of University Law College and all our faculty and students, extend you a very warm welcome to this program.
Welcome. Thank you very much. Thank you very much.
We have with us our esteemed colleagues, Dr. V. Sudesh, former Principal and Dean, Professor N. Dashrath, Chairman and Dean, Faculty of Law, Dr. Satish Gowda, Dr. Jyoti Vishwanath, Dr. Chandrakanti, members of the faculty, members of the guest faculty. I extend them all a very warm welcome to this program. We have with us the President of our Alumni Association, Sri Gautam Chandji, and other members of the alumni and members of the bar. And we have many distinguished invitees and guests who have participated in this program. I extend all of them a very warm welcome to the program. And I also welcome all our dear students of LLB, LLM, and PhD for this program. Thank you very much.
Thank you so much, sir, for extending a warm welcome to our guests and the participants who have gathered here virtually today. Okay, now I consider it my privilege to introduce the chief guest of today, that is Srimati Indra Jaisingh. Srimati Indra Jaisingh is a senior advocate of Supreme Court and is noted for her legal activism in promoting human rights causes. She did her schooling in Mumbai and completed a B.Ed degree from Bangalore University, which is actually a matter of pride for the students of Bangalore University, and LLM from University of Bombay. And in 1986, she became the first woman to be designated as a senior advocate in the High Court of Bombay. And also, she was also the first woman to be appointed as the Additional Solicitor General of India. She has argued several cases relating to discrimination of women and also sexual harassment cases, which indeed were successfully prosecuted. She has also argued in several prominent cases which related to environmental cases in the Supreme Court of India. She has been associated with the several People's Commission on the Violence, which, for instance, the violence in Punjab, to investigate the extrajudicial killings and disappearance of mass gravitation that took place during the period of 1979 and 1990. Indeed, not just that, United Nations also appointed 2 other experts along for fact-finding mission investigating the alleged killings of the Rohingyas in Myanmar and Rakhine State. Her contributions go on and never ending in numbers, and she inspires the youth, especially the young ladies, as she has proved that woman is not less and also can be the best in the pride. And she's Srimati Indra Jaisingh is the best example for it. It's indeed an honor to have you here, ma'am. So over to you, ma'am, now.
Thank you very much. Can you hear me well
yes,
enough?
madam. Yeah.
Okay, all right. Um, as the previous speaker pointed out, I did graduate from Bangalore University, Maharani's College. And indeed, I went to school in Bangalore. I finished my schooling from Bishop Cotton School. So I've always said that it's a pleasure for me to continue my association with the city of Bangalore. And for me, this is just one additional link to the city and to your university. I've had many students who have graduated from the university working with me as my juniors, and it's been a pleasure working with them. They are the evidence of the excellent quality of legal education that they received in the Bangalore University. And many of them have gone on to be designated senior counsel by the Supreme Court and by their respective high courts. So for me, indeed, it's a pleasure to be with you on Constitution Day. Now, I have chosen to title my talk, "The Constitution, Ignored or Respected?" question mark. And then I go on to answer my own question. So let me begin with what I call the origins of the Constitution. At a time when I see the Constitution being ignored rather than being respected in letter and spirit, it's important to mark this day as a day on which we attempt to bring the Constitution back into our lives. Let's begin by discussing how the Constitution came about in the first place. Many of you were not born when this Constitution came into force, but I was. I consider myself one of midnight's children, by which I mean I was witness to the stroke of midnight when India gained independence from British rule. And this, I think, puts me at a great advantage in understanding what exactly is going on in the country today. It's true that I was too young when the Constitution came into force, but it's equally true that I did inherit the values of the freedom struggle. Being a woman, I have been acutely aware that the freedom struggle was not just a struggle from British rule, but also a struggle from cultural, social, political, for cultural, social, legal, and political equality. It is important for me to recall that moment and remind ourselves what went into the making of the Indian Constitution. This is a quotation which I use very often. It comes from Justice D.Y. Chandrachud in his judgment, Indian Young Lawyers Association versus Union of India. And I quote, Para 74, for those of you who would like to go and revisit it. Reading Dr. Ambedkar compels us to look at the other side of independence from British, in the other side of the independence movement. Besides the struggle for independence from British rule, there was another struggle going on since centuries and which still continues. That struggle has been a struggle for social emancipation. It has been a struggle for replacement of an unequal social order. It has been a fight for undoing historical injustices and for righting fundamental wrongs with fundamental rights. And the quotation continues, the Constitution of India is the end product of both these struggles. It is the fundamental document which in text and spirit aims at social transformation, namely the creation and the preservation of an equal social order. The Constitution represents the aspiration of those who were denied the basic ingredients of a dignified existence, close quotation. Now, this for me sums up the origins of the Constitution. It also sums up for me what I inherited when I decided to become a lawyer. In my work, I have been influenced by these two struggles: the struggle for independence from colonial rule and the struggle for social emancipation. I have believed that law is an instrument of social change and have tried to use it in the service of democracy and secularism. The basic features of the Constitution. Our Constitution is an inspiring document, one of the few in the world which contains directive principles of state policy meant to guide public policy and the judiciary in its decision-making. It is a guide to the interpretation of the Constitution and to statutes. It is time we took the advice of Justice Krishna Iyer seriously, and he said, Gandhi, not Maxwell, should guide the interpretation of statutes, and I may add, the directive principles of state policy and not Maxwell should guide the interpretation of the Constitution. Independence movements in the global South, independence struggles, especially in India, have come to endow the state with central importance in the transformation of social relationships and bring about social change. This was a matter of choice. Independence movements have not only been movements that have faced an external enemy, but also the internal enemies of much bigger proportion in the form of extreme poverty, socioeconomic inequality, hierarchies of caste, race, gender, and much more. Therefore, the state that actively takes up the task of eradicating the internal inequalities has been the primary consideration for constitutional framers. In achieving this goal, the Constitution has also been a tool with which we, the people of India, have fought these internal enemies. Writing on India's constitutional moment, several scholars have expressed a similar sentiment, and I quote one of them. When one considers, for example, the directive principles of the Constitution or the strivings of the state, they include a fulsome engagement with matters of health, education, individual and communal safety, equality, and prosperity. The constitutionally enshrined vision of the future is what has been seen as implying an activist and capricious state responsible for creating the conditions for the exercise of our rights. The Constitution, which is the culmination of the ideals of the freedom movement, has been shaped by the social religious reform movements of the past, which, with the experience of communalism during the partition in undivided India, we fashioned a constitution which we called a secular constitution. Although the word secularism was not there in the preamble as drafted, it's a running theme throughout the Constitution. Care has been taken to ensure that the Constitution we adopted was secular and that there was a separation between religion and state, with every religion respected equally. India is probably one of the most multi-religious countries the world has known. Care with citizenship of Indians was not linked to the religion to which they belonged, but had civil and constitutional considerations in mind, such as birth within the territory of India. The disparities of gender and caste within religion came to light since the introduction of the modern education system into India during the period of colonial rule. So the reform movement started well before independence and continued into the constitution and in the post-independence period till this day. The disparities of gender and caste within religion came to light with the introduction, as I said, of the modern education system, even during the colonial rule. Among the inequalities that was addressed was sati, burning of widows, prohibition against widow remarriage, and then compulsory widowhood, which is very close to the burning of widows, the institution of child marriage, getting a girl married before she attains the age of marriage. These were the evils found to exist in Hindu society, which was sought to be abolished. The argument that these are linked to religion or that they form essential practices of religion was roundly rejected even during the colonial period and certainly by our constitution and in the post-independence period. It has also been rejected to a large extent by the Supreme Court of India. Inequalities were not limited to gender, but also discrimination found among castes in India. Many of you will be surprised to note that a statue of Manu exists in the High Court of Rajasthan within the premises, and efforts to get it removed have failed. Petitions have been filed pending in the High Court, which have not been brought to a hearing, calling for a removal of the statue, both on the ground that it offends secularism and on the ground that the Manusmriti notoriously discriminated against women. These social problems were turned into social reform movements by social thinkers during the freedom struggle in the country. Indian social reformers such as Raja Ram Mohan Roy also advocated and worked towards the eradication of backward social practices. It is these movements that inform the framing of the Constitution of India. So I would certainly like the students of today studying law in your university to be deeply conscious of the origins of the Indian Constitution and be true to them. This process of separating the secular from the civil, from the essentially religious, is reflected in the emphasis on the rights of the individual while equally respecting collective rights like the right to religion. We will say a few words a little later on what has come to be known as anti-conversion laws, more particularly in the name of quote-unquote love jihad. Nevertheless, the separation of religion from state is a basic feature of our Constitution. Ours is not a theocratic state, and no one religion can be privileged over another, nor is it the duty of state to administer religious laws for any community. I will now move on to my own personal journey in the law, only to illustrate a point of the kind of problems that my generation found itself in. I will say a few words about social and economic rights. Given that I was born and brought up in the values of the independence movement, it is not surprising that when I became a lawyer, I chose to start working on social and economic rights. I decided that my main task as a lawyer was to, through law, try to eliminate economic inequality. However, I understand that the abolition of economic inequality is a political issue and not just a legal issue. But the Constitution and laws are meant to be an aid for the political goals which we chose. It is for this reason that in the early phase of my career, I focused my attention on the rights of the homeless. In the now famous Olga Tellez case, I argued that pavement dwellers have a right to reside on the pavements for want of a home provided by the state, and that they could not be evicted without due process of law and without being provided alternative housing. I went on to handle cases of self-employed women. I worked for organizations like SEVA, headed by Ila Bhatt, who organized women vegetable vendors. I don't know how many of you have been witness to scenes on the streets of our metropolitan cities of the police coming with a danda and trying to remove vegetable vendors, men and women alike, sitting on the streets selling vegetables in marketplaces. They are told that vending of vegetables can be done only in markets, and they are not provided with space in markets, nor can they afford a shop in an established municipal market. I took up the cause of these hawkers, both men and women, in the Bombay Hawkers Union case, and I'm proud to say that I established what is known as the fundamental right to hawk as part of the right to carry on your trade, profession, and occupation. I would like you to understand how all these rights can be made applicable to marginalized communities if we use our imagination as lawyers. I remember at one point in the Supreme Court of India, one of the judges told me, but Ms. Jaising, what right do they have to sit on a pavement and hawk? They are licensees. And I had to turn around and remind the judge of the Supreme Court of India in open court, my lord, your institution, the Supreme Court of India, is also functioning on a license. You don't own the land on which it is built. A license in law is a very, very valuable right, and it cannot be terminated without due process of law. To the credit of the judge, the comment was not taken personally, and an appropriate judgment was rendered declaring the right to hawk as a fundamental right. I worked for the cause of women. Being a woman myself, some of the earliest cases I did were relating to discrimination against air hostesses working in Air India in the matter of promotions. It was a long journey, but ultimately, women air hostesses in Air India were granted parity in the matter of promotion with the male pursers. Since then, I've gone on to do many other important cases. There is not enough time for me to guide you through all those cases. The challenge to triple talaq in the Saira Banu case, the Shabrimala case, which entailed the right of women to enter the temple, and many more. But let me come back to another milestone in the journey of this country, that is the year 1975. when the emergency was declared. I would like to tell you that my generation did take our political freedoms for granted. We took secularism for granted. We took freedom of religion for granted. We took it for granted that religion and state were separate. We took freedom of speech for granted. We took the freedom to associate freely for granted. It was in 1975 that the emergency did come as a rude shock. But we stood up and resisted. And in 1978, the emergency was politically the emergency was politically rejected by the people of this country. Why do I remind you of these events? Because I believe that what we are seeing today is a creeping, silent emergency in this country. And it is for you as law students to recognize what is happening in this country is perhaps worse than what happened during the emergency. At that point of time, we at least had a written constitutional instrument to battle in our courts of law. We did, after the emergency was lifted, amend the Constitution so as to ensure that Article 21 could never be suspended, even during an emergency. We did, for example, amend Article 352, making it impossible to declare an emergency on the ground of internal disturbance. I will draw attention to the word, quote unquote, internal disturbance a little later in this discussion to alert you to the dangers that are awaiting you when you become practicing lawyers and the challenges that you will face in using law in defense of democracy and republicanism. And it is here that I would like to come to the heart of this lecture and to the title of this talk. The Constitution is being ignored. You see, if you can ignore the Constitution, why would you want to amend it? If you can ignore the Constitution, why would you want to declare an emergency? If you can ignore the Constitution, why would you want to enact new laws? You quite simply pretend that it does not exist. And that is what I think is happening today. Today, we see a different generation who's unable to recognize that there was a time when the Constitution was not being ignored. And it was respected in letter and spirit. Whether it is in the matter of governance, where we see the doctrine of collective responsibility of the cabinet being ignored, the accountability of the executive to the legislature being ignored, criminal laws being passed as money bills to avoid a discussion in the Rajya Sabha, laws not being referred to parliamentary committees, citizenship being conferred on the basis of religion, giving a go-by to our understanding of secularism, lynching of minorities becoming the new normal, then we have to only conclude that we are living in a state of lawlessness and we are living in a state which is not governed by the Constitution of India. We talk about the rule of law, but we need to understand, are we still a nation governed by the rule of law? Having said this, I will move on to what I consider to be by far the most important right. My experience has taught me that the most important right in the Constitution of India is the right to free speech. It is the marriage of the right of free speech with our social and economic rights which will lead us to a state of liberation from economic inequality and discrimination. Marriage with minus this one partner, namely the right to freedom of speech, our civil and political rights, we will never be able to achieve the end of economic deprivation. We, as marginalized communities, have no weapons in our armory. We do not take to arms. We protest peacefully. We don't have networks within the state. We do not, very often, we don't contest elections to get elected to state power. But we do have this very important weapon in our armory, that is the right to free speech. If that weapon is silenced, all is lost. And it is my categorical submission that this weapon of free speech is almost silenced in India through a variety of devices, which does not need the declaration of an emergency. And it is that is why that you hear people of my generation talk about the idea of India. I'm sure many of you have heard this expression, the idea of India. So when we talk about the idea of India, we talk about a return to the values on which this nation was founded. I've already talked about these values, so I will not repeat them. We point to the indivisibility of rights. We point to the fact that without civil and political rights, social welfare is meaningless. Even if social welfare benefits are delivered to the last mile through devices such as Aadhaar, which incidentally they are not. Aadhaar is more a tool of exclusion than of inclusion. Even if bank accounts are opened in the name of every single person in this country, if you lose or negotiate away your right to free speech in return for these crumbs which are being put on your table, then all is lost. And that is why I have personally reached the conclusion that my work should be devoted to the defense and the restoration of the right to free speech. When I look around me, I see young students being picked up and thrown into prison for protesting the CAA, for protesting the conversion of the state of Jammu and Kashmir into union territories. We are not here to discuss the rights and wrongs of these decisions, but I do say that we have the fundamental right to put forward an alternative point of view, peacefully, collectively, and legitimately. We are living in times when we can be victimized for being the lawyers we are. We are living in times while lawyers are being victimized for representing a cause in court. I am an example of one such person who has been victimized. Every single state agency has been let loose against me, as it has been against many others, in the name of Foreign Contributions Act. You don't need a reason. There is state power, and state power can be used for illegitimate aims. This is what you have to identify in your day-to-day work as you move forward becoming lawyers. So let me talk a little bit more about some of the weapons that are used against conscientious dissenters. They're called anti-national. The law of sedition is used against them. The law of UAPA, Unlawful Activities Prevention Act, is used against them. Leading intellectuals in the country, recognized worldwide, are today behind bars. All of you might know that I have recently argued for the release of renowned poet Varavara Rao from jail into a hospital in defense of his right to health. Learned lawyers were unable to agree with me when I said the conditions of detention are subject to judicial review. As far back as in Sunil Batra in 1976, the Supreme Court had declared that conditions, that incarceration does not mean that you lose all your fundamental rights, but only those which are inconsistent with the right to freedom of movement. I would like to say a few words about the use of sedition in particular. First, I think it's very important to read, go down please, to read the literal words of section 124, and I will read them out because I want you to focus attention on every single word. Whoever by words, whether spoken or written, or by signs, or by visible representations, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law, shall be punished with imprisonment for life, or with a fine which may be added, or with imprisonment which may extend to 3 years, or a fine which may be added, etc. Explanation 1. The expression disaffection includes disloyalty and all feelings of enmity. Explanation 2. Comments expressing disapprobation of the measures of the government with the view to obtain the alteration of by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. Explanation 3. Comments exciting disapprobation of the administration of another actions of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. Now, 1978, having read the section, I want you to focus your attention on a few words. To begin with, please remember that this section was introduced during colonial rule. Very important for you to remember. The relationship between a colonial state and a subject, and that between a citizen and a democratic state, is very different. Whereas a subject to colonial power had no fundamental rights and was expected to be, quote unquote, loyal, a citizen of a democratic state owes no such blind loyalty to anybody except perhaps their own conscience. And therefore, a section like 124A has no place in a democratic constitution. It's not about saying that sedition occurs only when it's associated with violence. No, it's a question of saying sedition has no place in a democratic constitution, period. Even so, the expression used in 124A is hostility towards the government. Now, here you need to understand that there is a difference between the government and the nation. I might have a hostile understanding of the public policy of a government, but not of my nation. I may be a very patriotic person. I may be a very law-abiding citizen. I might have great love for my country, Bharat, that is India, and yet not have the same respect and love for a government, which I believe is undermining the constitution which I inherited. What we see in the country today is a demand for unquestioning, undying loyalty to a government which is in power. This is anti-constitutional. To move on to the expression anti-national, there is no definition of anti-national in any of our laws. Please be very clear about that. I request all of you to search through the Constitution, through your laws, and come up with where you will find a definition of anti-national. There is some evidence to be found in the Defense of India rules of 1962, which deals with subversion of armed forces. The Indian Penal Code also has a range of offenses, beginning from things like simple hurt when it comes to violent activity, and ending with something as grave as waging war. And while you can say something like waging an armed war against the state is an anti-national act, by no stretch of imagination can you say that protesting the CAA or the abolition of Section 370 is an anti-national act, at least not in the eyes of the Constitution of India. So I believe that it's very important for you as students, more particularly students of law, to pay attention to the language of the law. I believe that anyone who reads the words of section, go further, words of section 124A of the Indian Penal Code will come to the same conclusion that I have come to. Now, that being said, I would like to move on to my concluding comments. But before I do that, on the issue of the right to dissent, I'd like to quote from a judgment of Justice Sudarshan Reddy in the Selvajudam case, and on the right to dissent. And this is what he said. The core aspect of democracy is the freedom of an individual to be able to freely operate within the framework of the laws enacted by Parliament. The individual should be able to order his or her life any way that he or she pleases, as long as it is not violative of the law or constitution or an infraction of any order or direction of a duly constituted court, tribunal, or any statutory authority for that matter. Amongst the various freedoms conferred on an individual, that is the citizen, is the right to free speech and expression, which necessarily includes the right to criticize and dissent. The right to criticize and dissent. Criticism by an individual may not be palatable. Even so, it cannot be muzzled. Many civil rights activists believe that they have the right as citizens to bring to the notice of the state the incongruity in the developmental policies of the state. The state may not accept the views of the civil rights advocates, but that by itself cannot be a good enough reason to do away with dissent. That is the centrality of the right to dissent. When it comes to expressions like security of state, they are very well defined, and they do not include causing public disorder or causing a riot or causing a local disturbance. security of the state is often threatened by external aggression. Being a sovereign nation, sovereignty lies with the people of India and not with those who rule India. Yeah, I think I have said enough about what the Constitution means to me and what I see as the challenges that will be presented to you when you become practicing lawyers. And of course, it is up to you to decide how you're going to face it. I can only tell you that my life's experience has taught me that it is not enough to focus on bringing to life social and economic rights in a court of law. It is equally important to defend the civil and political rights of every single citizen of this country. I would like to end by saying that the challenges that why should I talk about you? I will talk about the challenges that I face. I faced the challenge of defending a secular democratic constitution. And on this Constitution Day, I would like to remind myself of these two things. One is the founding vision of the Constitution, and two, of the need to defend that vision. Thank you very much.
Thank you, madam. Thank you very much for your valuable address. And I also take this opportunity to thank Sri Mohan V. Katarki, who has kindly graced the program and who is a senior advocate of Supreme Court and also a distinguished visiting faculty of University Law College. Recently, our Honorable Vice Chancellor has been kind enough to permit us to have 5 distinguished visiting faculty who are eminent senior advocates of Supreme Court and High Court. And all of them have kind enough to accept our invitation, and they have started delivering the classes. Thank you very much.
That was indeed an informative and very informative and enlightening, ma'am, and it was quite indeed relevant, ma'am. Thank you so much for the thank you so much, ma'am. Now, I would like to acknowledge the presence of a very eminent professor, Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University. Sir is an IEEE Fellow and ACM Distinguished Educator for the contribution on the Fraternity of Computer Science. He holds 11 degrees, 2 PhDs. He has authored and edited 72 books in computer science, engineering, and also economics. These books are prescribed as textbooks in reference not only in India but also abroad. The royalty of these books are is that the income is actually entirely donated to the charitable educational institution as a welfare of the students. He's also a social worker, researcher, inventor, inspirer, and a very simple, pleasant personality known for his dedication, charity, and commitment, and honesty and sincerity. It's indeed an esteem to have you here, sir. And I now request Professor Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University, to deliver the presidential address. Over to you, sir.
Thank you very much. Today, indeed, it is a very great day that I'm sharing the dais, virtual dais, with an eminent lawyer, Srimati Indira Jaising, who is an alumni of Bangalore University. She has completed a bachelor's degree from Bangalore University, and we are very proud, madam, that you are also an alumni of Bangalore University. Today is the Indian Constitution Day, November 26th, 1949, when the Constitution was adopted. So we have to pay tributes to the drafting committee. The drafting committee consisted of Alladi Krishnaswamy Iyer, Gopala Swamy, K.M. Munishi, Muhammad Sadaullah, B.L. Mittal, Kiripi Kaitan, and its chairman as Bharata Ratna B.R. Ambedkar Sahib. If you see the constitution of this country, it has characteristic from UK, USA, Australia, USSR, Germany, Japan, Canada, South Africa, Ireland. Such is the richness of this constitution. It is one of the longest constitution, biggest constitution, largest constitution governing 1.3 billion people of this country. It is the largest democracy that is existing on this world. Today, we have heard Srimati Indira Jaisingh on a discourse on how this constitution has survived, how this constitution has been upheld by thousands and thousands of lawyers who have defended this constitution over the last 70 years. Now, to take an example, Madam said that lynching, religion, secularity, all these were distorted in earlier days, and how even Manu law, which was biased in the earlier this thing, and they were not able to remove the idol of the statue of Manu. But Manu, at that time, the law looked very nice at his times, and that is only about some 3,000, 4,000 years back. But 4,000 years later, we have to move on to a constitution which might be having only few things that are very similar to Manula. And because it is the changing dimension of this civilization. This constitution has ensured how Article 21 and Article 352 cannot be suspended. And we have seen the emergency that has been imposed on June 25th, 1975. I was a student of first year engineering, and I was taken to the police station on the next 3 or 4 days later, and in the evening I was released. But still, we all fought, and we have seen that the constitution has been, upheld in this country. Now, if you see the emergency was withdrawn in March 17, 1977, and when the elections were held, the mandate which was given is the confidence that the people reimposed and they had in the constitution. This constitution is so robust that it has survived 70 years, and this constitution is so good that it has instilled faith in the people of this country. And we have called it, however, when Bharata Ratna B.R. Ambedkar said in his own words, to quote, "However good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution be, if those implementing it are good, then it will prove to be good." I am so happy when I read this sentence. I read it again, I quote again and again in all my speeches. And one more thing which was very fascinating of Dr. B.R. Ambedkar Sahibji is, I measure the progress of a community by the degree of progress which women are achieved. And today, when I see Srimati Indira Jaisingh talking about this constitution, I feel proud that so many women in this country have been defending this constitution. Thank you, madam, for giving an enlightening lecture today. And I'm really, so happy that women in this country have been so enriched with the constitution given by Dr. B.R. Ambedkar. Now, if we have seen how this constitution has come up over years, it might be 1858 Government of India Act, or it may be 1861 or 1892 Indian Council Act, or 1909 and 1919 Montagu Chelmsford Minto Morley reforms, and 1935 Government of India Act, and finally 1947 Indian Independence Act. And if you see that these 7 members of the drafting committee have given a wonderful Bhagavad Gita to us. Bhagavad Gita might be not secular, and now here we have a constitution which is secular, which has incorporated all religions, all types of ethnic committee, and all type of races that have been integrated into this country. Long live this constitution, and long live the ideals of Dr. B.A. Ambedkar. And thank you, Srimati Indra Jaising, for your illuminating lecture. And I thank Professor Suresh Nadagaudar, principal of the college, Sudesh, former principal, Dasrath, chairman and dean, then Satish, Jyoti Venkatesh, and Chandrakanti for, conducting this program and leading to a successful and leading all the students and the erudite scholars to do more research and to, keep this flag floating high for years to come. Thank you, one and all.
Thank you, sir. Thank you very much for your very enlightening presidential remarks and for all your support and blessings. Thank you, sir.
Thank you.
Thank you so much, sir. So I extend the gratitude to all the dignitaries of the session, and I request Professor Dr. N. Dasrath, sir, Chairman and Dean of Department of Law, University Law College, Bangalore University, to propose a vote of thanks.
Yeah, very good evening, one and all. Respected Speaker of the day today, Madam Indra Jaising, Senior Advocate, Supreme Court of India, respected Honorable Vice Chancellor of Bangalore University, Professor Dr. K.R. Venugopal, sir, respected Principal of University Law College and Department of Studies in Law, Professor Suresh V. Nadagaudar, respected Professor V. Sudesh, respected members of the teaching faculty, Dr. Satish Gowda, Dr. Jyoti Vishwanath, Dr. Chandrakanti, respected principals, heads of the departments of various departments of Bangalore University, respected lawyers, respected president of the Alumni Association of our college, and the students, both undergraduate, postgraduate, and PhD, members of the media, and all others present on this very, very auspicious day, the event being celebrated as the 71st Constitution Day in our great country. At the outset, I thank the government of the day today for declaring this day to be observed as the Constitution Day from 2015 onwards, rather calling it as National Law Day. One it tributes to the chairman of the drafting committee for his tireless effort, along with the most erudite scholars in the Constituent Assembly, who have taken 2 years, 11 months, and 17 days to draft this great constitution of this great nation. Madam Indra Jaising, a very senior advocate, your voices have been able to save the lives of the victims of the dowry in this country, the victims of the domestic violence in this country, the children being victimized in this country, the downtrodden, and all other concerned people of the vulnerable community. Your voice from the Supreme Court of India, from the National Capital Territory of Delhi, has been helpful to save all the people whom I have referred. I am extremely happy, madam, to be in our midst in your home city, Bangalore. And we are very proud, as our Honorable Vice Chancellor has expressed, that you are the alumni of our Bangalore University. On behalf of the Bangalore University, University Law College, Department of Studies, and all others present here, I extend and register my vote of thanks to you, Madam. I thank the Honorable Vice Chancellor of Bangalore University, Professor K.R. Venugopal. Words are not sufficient to tell about his personality. I could only, and I would only say, our Honorable Vice Chancellor always inspires us to think good, to do good, and be good in society. These words always I remember from his mouth, and I feel every one of us should try to inculcate these feelings of our Honorable Vice Chancellors to do good and be good in society. I thank you, sir, on behalf of University Law College and Department of Studies in Law, Bangalore University, and all other concerned present in this very auspicious occasion.
Thank you. Thank you.
I thank the principal of this great institution, University Law College and Department of Studies in Law, which is in recent times is in discussion amongst every academic circle at national law school level, state law school levels, traditional universities, and elsewhere for organizing series of webinars, national, international, and series of law lectures for the benefit of the students. I thank you, sir, for all your effort along with all our team as a family in the University Law College and Department of Studies in Law.
Thank you, sir. Thank you.
I thank Professor V. Sudesh, who has contributed immensely for the growth of the institution in the capacity of principal, chairman, and dean, and he continues to do the same. And on behalf of everyone present here, I express my thanks to you, sir. I express my thanks to my colleagues in the department, Dr. Suresh, Dr. Satish, Dr. Jyoti Vishwanath, Dr. L. Chandrakanti, Madam Librarian Shivkumari, and all others who are present here and have made this event a great event and made this function more meaningful. Great success. Jai Hind, Jai Karnataka. Thank you.
So thank you, sir. Thank you very much, madam, for sparing your valuable time and enlightening all of us on the various nuances of Constitution. Thank you.
Thank you for inviting me.
Thank you, madam. I am Venugopal, Vice Chancellor. Thank you for your wonderful discourse. Thank you. We'll see you in Bangalore. When you come to Bangalore, we'll try to meet you, madam.
Thank you, sir. Thank you very much.
Thank you so much, Professor Dr. Darshit, sir. This we conclude today's event now. So I oblige the University Law College Department of Studies in Law, Bangalore University, for giving me this opportunity to hold this session. And I would like to thank Professor Suresh and V. Nadagaudar, sir, for giving me this opportunity, sir. Thank you so much, sir. Thank you one and all present here, and have a pleasant evening.
Okay. Thank you. Thank you all. Thank you all our colleagues. Thanks.
Thank you
And all our students for gazing the program.